What's up? What's up? What's up? It is Bad Wolf. Once again, I appreciate each and every one of you guys. Imagine me with a lot of hair. Ooh, are you down with the legal system? I appreciate you guys as always. You guys gotta have to have a little here, Wolfie. His ears. Oh, that's just my bad wolf mask. When I'm out there wolfing it up. As a legal person, you got to wear the mask of the strong man. Why do I say it like that? Oh, because I'm just a mad man in the blue box. For those people who know the reference to the bad wolf. Huzzah. Why do I say it like that? Because we're going to be talking about the all caps name. Now, I've already showed you guys why I would win the Supreme Court case on the use of the straw man name, because the person whose case I read through did not argue the correct points of law. They couldn't bring it together. I can. I've already showed you guys. However, that is not my fight. But I'm giving you guys the information. If somebody wants to pick up the mantle, you're more than welcome to use it. All right. I've proven it. I've shown it to you. But we're going to take a look at somebody else's work here. So fair use, all rights reserved, all that good jazz, blah, blah, blah. And I'll give credit out to that person in a moment. Um, they've done the work, pulled together a lot of informational pieces and have it in one nice website uh, to be able to be read. So public use and fair use. Let's take a look. We're going to be talking about the name in all caps and why it's what some people have referred to as grammatical deception. Okay. Really, it's just understanding the correct style and for the jurisdiction and where you can prove that it is in fact a representation of you as a business or legal person. Let's take a look. As always, guys, have a great day. Be positive. I appreciate each and every one of you guys. I pray for all of you good people out there for nothing but good, positive things to come your way. If you guys are suffering, if you guys need help with any financial assistance, unfortunately, my pockets are not that deep, but I do appreciate donations, blacksite32.com. But also on blacksite32.com, you guys can find a lot of benefits, programs, things where you guys can get a lot of assistance, everything from financial help to whatever, food, etc. I try to put all those things up there. So please scour through that site. I haven't met almost anybody except for other people out there that don't like me, government or other nationals for their reasons, to ever say that I didn't provide enough free stuff, free files, free help. So if you guys could do me a favor, hit that bell, like, and subscribe. Thank you in advance. Welcome to the tribe. And as always, anybody out there, if you guys are sick, I pray for your healing mentally, physically, socially, whatever it is. I pray that you have help or that healing energy comes to you, and even financially, whatever it is. All right. Um, Otherwise, when you're on Black Site 32, get that newsletter. That is where, when I start to launch out all of the things in advance, the special VIP. If you want to be VIP, there's two ways to do it. You can do both, but at least one. Either get the newsletter and find out things before they happen and I launch them, or join YouTube, my channel, main web page, click on the join and support monthly, and then have access to those videos. Okay. Let's get going. Special shot goes out to Gordon Warren Epperly. Once again, fair use. It is on the internet. Anybody can look at this. Some of this may possibly be his wording. A majority of it looks like bits that he has put together from other places. So fair use on this. With that being the case and being said, looks like his website or this website that's hosting it is USA versus US.info. So all rights reserved. Fair use, fair use, fair use. Let's get going.
Many people are involved in diligent research concerning the use of all capital letters for proper names, e.g., John Paul Jones as a substitute for John Paul Jones in all court documents, driver's licenses, bank accounts, birth certificates, etc. Is the use of all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official judicial or U.S. government rule and/or style of grammar? Why do attorneys, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What English grammar experts say. One of the foremost authorities on American English grammar, style, composition, and rules is the Chicago Manual of Style. The latest, 14th, edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. Since we can find no reference in their manual concerning the use of all capitalized letters with a proper name or any other usage, we wrote to the editors and asked this question. Is it acceptable, or is there any rule of English grammar, to allow a proper name to be written in all capital letters? For example, if my name was John Paul Jones, can it be written as John Paul Jones? Is there any rule covering this? The editorial staff of the University of Chicago answered. Writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wind appears on the title page all in caps, we would properly render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We're not sure in what context you would like your proper name to appear in all caps, but it is likely to be seen as a bit odd. Law is extremely precise. Every letter, capitalization, punctuation mark, etc., in a legal document is utilized for a specific reason and has legal, i.e., deadly force, consequences. If, for instance, one attempts to file articles of incorporation in the office of a Secretary of State of a state, if the exact title of the corporation, down to every jot and tittle, is not exactly the same each and every time the corporation is referenced in the documents to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person.
This is why when you go to the bank, they ask you, is this the correct spelling of your legal name or of the legal entity, the correct address? If it is off, now you understand that when I tell you guys, when you make your trusts, do not use your legal name, because that is a legal person. It is not you. It is a dead thing that you control, like a vessel, a ship, a mask, or a suit. You can put things in its pockets. It is registered to the state. And anything you put underneath that name that you think is yours in that spelling format is underneath it, and it is underneath them. They can administrate it. You create your trust name. Now, your name can be in the document, but not the name of the document. That should be foreign. I use Lovett. I changed Lovett into Lovitica by adding ICA on the end, which makes it a new thing, a new entity, a new legal person, if you will, but it's not registered to them. It's in their waters. I can come there and do business around them, with them, through them, but they have no jurisdiction over it. And I'm not waiving my rights to that freedom and privacy unless I do something criminal or illegal directly to them. Now, to once again reiterate why the person in the court lost their case is because they didn't reference the Chicago style manual. They didn't reference Black Law's dictionary on capitis dimitio maxima. They failed because they did not mention the UCC under conspicuous format, UCC 1-201, I think it's letter H, or conspicuous format, in the use of the all caps. So when they brought their case to the federal court, who does not use capitis dimitio maxima, they do not use the UCC, they are not subject to it. The federal judge knew what he was trying to convey because he's smart, but he's not going to give you that information. You have to convince him of what he already knows. You prove it. You're here to prove it. He failed. I wouldn't have. But let's keep going. Gem drops.
It is therefore an eminently valid.
Drop in gems for all of you privates, pirates, privateers. Did you know that the first pirates were actually Templars who went private? Did you know that the first banks, when they were good, were Templars and they were private? And they had, and the Pope and the king had a problem with that because they owed those Templars money. So they hate the private because everything that they were doing was public. The first pirates were privates. They were private people, privateers. They didn't like them. Now you understand. Pirates were not necessarily the bad people. Neither were the savages. But listen to how your mind, the moment I said pirates, thought negative. How when I said savages, you thought, oh, unruly beasts. No. They brainwashed us. Let's get back to it.
Valid, and possibly crucial, question as to why governments, governmental courts, and agencies purporting to exist, in some undefined, unproved manner, within the jurisdiction of this state insist on always capitalizing every letter in a proper name. Mary Newton Bruder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question. Why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is John Paul Jones, is it proper at any time to write my name as John Paul Jones? Dr. Bruder's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it.
Okay, now let's break this down here. She was telling the truth, but she also didn't do as much research as I have, but I thank her for her work moving forward. We become great by standing on the shoulders of great people. She said it must be some type of internal styling. That's correct. Trying to see if I have the books right here or where I've moved them. Okay, they're there somewhere. So one is the blue book on legal style. The other one is the Chicago Manual of Style. You can also look up the UCC when it comes to using that particular style. Conspicuous format, UCC 1-201. And Black Law's Dictionary, all which they use and reference. And their legal department knows exactly what I'm talking about. But the people above them do not. So when there's an issue raised on something legal and you're arguing with a judge, most of them know, or some officer, they don't know any of this. You've got a problem because only the legal department is going to, and if you challenge and invoke that this be run past the legal department, will it then make it to them and they will back the hell down. Let me break it down into a simpler way for you guys to understand it. Um, when you create a business, go right now to your state of whatever and go create a business. That business, 100,000%, I guarantee you, unless this video is watched in the future and they change something, 1,000% guarantee you infinitely that your business name will be presented at some way, shape, form, or fashion on their paper as all capitalized, which means it's a style, which means it's their internal style to their corporation. Their corporations operate under the U.C. Google it, ask ChatGPT. The government does not. The government works and operates under the Constitution for the American people. Two different jurisdictions, the state, the federal, Constitution, state, corporate. They operate underneath them under our umbrella. They're in our family. They're a part of the Lovett family, but their real last name is Johnson, but we're going to consider them a Lovett. So they're one of us, but they're not us. They rock their gold fringe flag and their corporate statutes and codes for people in their jurisdiction, not the physical area. They don't own the physical area. We do. That's America's land. They're operating above the same geographical area as a separate bubble under the American bubble. We're in it. They are gods in their own bubble, but they're still subservient to the big bubble. They're the little kids in a sandbox in the backyard. That little sandbox is called DC. When you use anything that's their zip code, no matter where you are geographically, it is considered to be from where you're standing, run through the District of Columbia and back to you as a pass through. That's what all these corporations are. Taxing and all that's done as a pass through. As their then federal territory. But they do not look at the physical ground. There's no actual zip codes on it. It is the republic. It is the land of the free, right? So it's free land. But not when you start to use their things. You are registering. You should have only been recording your things with a receipt. When you register, you are registering it. You're taking it from here, putting it in there. You're residence. You're creating a residency. To actually be there is residency. A resident, residing and enter. You're residing yourself through the District of Columbia, their corporations, and back to where it is physically located. You've elevated it from the geographical continental United States of America to the U.S. corporation and its subsidiaries in the same spot. Didn't even move your house, but you use the zip code. When you got your mail, when you got your driver's license, when you got your bank account, they asked you to prove residency. They said, you prove that you are a resident. We can't do it. Please show us that you've resided and then we'll give you all these beautiful things, these benefits in the Wizard of the United States, Oz. Dorothy, look at all the beautiful things. Do you understand in that movie what the Tin Man really was, right? TIN, tax identification number, straw man, the cowardly lion, the American who doesn't know that they're lions or wolves in this case. So she was right when she said this was internal policy because it's not Americans' jurisprudence. You're not going to find it in there. So when you talk to them about it, they don't know. Legal, officially, they don't know, but a lot of them really do know. But they can't say anything because that's interfering with the state's business. The government, which is why they watch my channel. Hi, guys. They need you, the American people, to file the lawsuits against what these people are doing properly. Don't just do it willy-nilly. It wastes time and money, and then you make everybody look stupid. They can't interfere with your business until you bring those lawsuits to them properly with the correct information. And with what's in this video and the other videos I've made, you guys have it if you choose to use it, educationally speaking. You bet your sweet ass they know who I am. For many reasons. They don't know who you are. They know I'm not going anywhere or do anything but opening the door. You guys have to walk through and take it to the house. Take it to the house. That's the way we take it to the house. If you want your freedoms, your rights, your liberties. If not, keep your cage shut and your mouth as well, and let them shear you, take your milk, take your meat, take your whatever, and be happy about it. Sweet potato pie, and I shut my mouth. Gone with the wind. Oh, sorry. All right, once again, just your favorite neighborhood madman. All right, let's get back to it. So she was right when she said it's an internal policy, and there's nothing in American grammar about it, because even if you go to the style manual, GPO style manual, and you look up capitalization, alphabet, and use of capitalized rules, it says, though there may be, and this is why the government, they know what they're doing, but they can't interfere with the business. It says other nations, countries, and local custom usages of the all capitalized names may be implied or in usage, but the American government does not utilize it. So your name in all capitalized letters on your passport, when done properly, is in fact you. Not on the state level. State level operates under the U.C.C. and they use conspicuous format. UCC 1-201. Look it up. I think it's letter H, if I remember correctly. If not, it's under the term conspicuous format in the beginning of the book. Holla at you, Wolf. Let's get back to it.
It seemed that these particular grammatical experts had no idea why proper names were written in all caps, so
I
he
do.
began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer.
Let's go.
What English grammar reference books say? Manual on Usage and Style. One of the reference books obtained was the Manual on Usage and Style, 8th edition, ISBN I-878674-51X, published by the Texas Law Review in 1995. Section D, Capitalization, Paragraph D, 1:1 states: always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things, e.g., Dan, Austin, Rolls-Royce. Paragraph D, 3:2 of Section D states: capitalize people, state, and any other terms used to refer to the government as a litigant, e.g., the people's case, the state's argument, but do not capitalize other words used to refer to litigants, e.g., the plaintiff, defendant Manson. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law is no excuse, or violation. One violating the law he enforces on others is acting under title of nobility and abrogating the principle of equality under the law of law. They continue to write plaintiff, defendant, the state of Texas, and proper names of parties in all capital letters on every court document.
So here's the thing. The state of Texas, which is different than Texas state or Texas Republic, when that is an entity, this is a legal person operating over the same area that is known as Texas state or republic. The republic can't stand up and say much for itself because it's the people and the people are divided. So there is no official municipality or government agency called state or Texas state. It's the people. The people have to get up and do something. But the state of Texas, a legal person, a municipality, a government, it can say things. So business-wise, they are supposed to capitalize these things. It's a corporation. So all they're doing is they're capitalizing a corporation. You're going up against who? The state of Texas. Okay, the state of Texas is a legal person. They deal with legal persons, not the living. So when you show up and you are the defendant or the plaintiff, whatever, they put your name in all caps because they're talking about your straw man. Your straw man is going to court. You are there on its behalf. That's what's going on here. And these people don't understand it. They don't get it. They don't understand the subtleties of the law. I study this stuff on the legal level. There is no deeper than that. I've had the people, and I know they watch at Cornell Law, change some of their things and capitalizations because they did it wrong. I am not talking jazz, but yes, these are facts. My IQ is in 161 range. That is genius level. Doesn't mean I'm perfect. Does not mean that other people aren't smarter than me in many different ways and things. But I am in very smart, very deep critical thinking. I was redesigning electrical circuits, creating new software, new computer languages, to the point where teachers were so mad at me after being taught by them, they thought I was cheating somehow. This was before the internet. Well, before the internet really got to where it is now, we'll just say. But I wasn't cheating. I just understood it. It made sense. And I had to literally go and talk to the dean who knew I was not cheating or doing anything bogus. And I passed with flying colors. Even was interviewed by her and got a AAA rating, which was something new they had to create because nobody ever aced it the way I did. I changed the game everywhere I go. Everywhere I go, I see the same hose or whatever. Don't forget, I believe in you guys, and I want you guys to understand this information so you know what's really going on. When the government, the federal government does this, all caps, it's just to make it more visible, clearly professional. When the states do it and lower, it is business. It's a commercial legal person. Let's keep going.
Document. The Elements of Style. Another well-recognized reference book is The Elements of Style, 4th edition, ISBN 0-205-30902X, written by William Strunk, Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization, located within the glossary at proper noun, page 94, where it states, "The name of a particular person, Frank Sinatra, place, Boston, or thing, Moby Dick." Proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a practical and authoritative guide to contemporary English, published in 1996, at Chapter 9, Email, Conventions and Quirks, Informality, states, "To give a message special emphasis, an emailer may write entirely in capital letters, a device emailers refer to as screaming." Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limit many networks. Here is a reference source, within contemporary, modern English, that states it is of an informal manner to write every word of, specifically, an electronic message, aka email, in capital letters. They say it's screaming to do so. By standard definition, we presume that is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum?
If they're shouting at us legally, it could represent that we're dead entities. If you're a dead entity, you can't hear, so you're yelling at them. Are you alive? Do you understand me? Can you hear me? Hello? Nobody whispers or normal talks to a dead body. So that could be the symbolism there. Everything that they do has a symbolism point. It's just my theory on it. Just a thought.
Decorum of a court if everyone is yelling? Is the insurance company screaming at us for paying the increased premium on our policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys and the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English. The New Oxford Dictionary of English is published by the Oxford University Press. Besides being considered the foremost authority on the British English language, this dictionary is also designed to reflect the way language is used today through example sentences and phrases. We submit the following definitions from the 1998 edition. Proper noun, also proper name. Noun. A name used for an individual person, place, or organization, spelled with an initial capital letter, e.g. Jane, London, and Oxfam. Name. Noun 1. A word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parsons, John Parsons. Kalkwasser is the German name for lime water. Verb 2. Identify by name. Give the correct name for. The dead man has been named as John McIntosh. Phrases. 3. In the name of. Bearing or using the name of a specified person or organization, a driving license in the name of William Sanders. From the Newbury House Dictionary of American English, published by Monroe Allen Publishers Incorporated, 1999. Name N. Esse, a word by which a person, place, or thing is known. Her name is Diane Daniel. We can find absolutely no example in any recognized reference book that specifies or allows the use of all capitalized names, proper or common. There is no doubt that a proper name, to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters.
However, in Black Law's dictionary, which is not American, it's used in America or the U.S. Corp, it has 3 Latin terms for 1, a full loss of rights in name, 2, some loss, but not all, and minimal, the third one, to no loss of rights in name. Now, this could be legally, I have to say, it could be conjecture, but if they're telling you under what's known as capitis, meaning to capitalize, dimutio, diminish, maxima, so capitalize is a double entendre. It means it has 2 meanings. Capitis is to capitalize, like to build a Capitol building and your columns, to capitalize it, to make larger. And it also means to capitalize to make money on or to gain ground on. So if these are the definitions of capitalization, and they're talking about a full loss of your name and rights and family, it's not a far stretch, especially per the U.S. U.C.C. under conspicuous format, to bring that together, that the 3 different ways we write our name is all capitalized, upper and lower, and all lower. All lower would be natural format, which they talk about in the U.C.C. So within their jurisdiction, they're saying that if you write your name normal, which is all lowercase, you have no loss of rights. You are private. You are a state citizen. You are a national. You are a non-resident. You're not their property. Upper and lower means you are somewhat in their jurisdiction, kind of their property, but you still have rights. But the all caps says a full loss of rights and name, status. So if you can lose 100% of your rights, name, family, and status, which was what the Romans used to do, and the ancient, I don't know if it was the Atlanteans per se, so I'll leave them out. I can't prove that. But the ancient Romans, when they would have a slave or a dead thing, like we have on ships, tombstones, businesses, and you're dead, it was depicted by all capitalized lettering. Capitis dimutio maximum, a full loss of rights and diminishment by the capitalization of your name. Let's keep going.
Letters. U.S. Government Style Manual. Is the spelling and usage of a proper name defined officially by U.S. government? Yes. The United States Government Printing Office, in their Style Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writing. Chapter 3, Capitalization, at Section 3.2, prescribes rules for proper names. Proper names are capitalized. Examples given are Rome, Brussels, John McAdam, McAdam family, Italy, Anglo-Saxon. At Chapter 17, Courtwork, the rules of capitalization, as mentioned in Chapter 3, are further reiterated. 17.1. Courtwork differs in style from other work only as set forth in this section. Otherwise, the style prescribed in the preceding sections will be followed. After reading Section 17 in entirety, I found no other references that would change the grammatical rules and styles specified in Chapter 3 pertaining to capitalization.
Now, here's why this person they didn't understand what was fully going on. They didn't understand that the government operates under the Constitution and American jurisprudence. But that system is not the same as the states. Not in these maritime courts. They have a slightly different bubble. They have abridged the Constitution, which is legal for them to do as business within their own jurisdiction. You can't come to my house and tell me I have to combine purple and peach Kool-Aid. I can do what I want to do here. I'll mix purple and cherry. Who's going to stop me? You come to my house, guess what Kool-Aid you're getting? Purple and cherry mixed together. Yeah, but out here, I don't care about out there. That has nothing to do with me. So this is my challenge to the federal government, because I know you guys watch it as well. After reviewing this video, I, as an American national, a state citizen, putting this information out there, that you have my permission to get involved in these matters. We are taking this public matter, which is considered to be for the U.S. citizen, and we're putting it on the forefront into the true public. There, I said it. This president has been put out there. Nobody said it before, I'm saying it. I give the government permission to get involved anywhere where there's an affair out there, where they're using this grammatical deception on these lower levels against us unlawfully. Now, this doesn't mean that they can just take it over for everybody, but this means that the precedent has been set. Now they know what's really going on lawfully. Defend us, protect us, respect us, represent us on our behalf. That is your job. You are so charged, every agency that operates under the United States of America and is constitutionally bound. Let's keep going.
Capitalization.
Oh, wait. So understand that in the GPO style manual, the part that they left off is that it says that in other areas, there may be local usages and whatever else, but we do not appertain to it. We don't use those things. We know there are other meanings behind the full name being capitalized. We don't use them in the US government. But other places, the state of your state here, your state's name here. Cough, cough, wink, wink. May in fact have a double meaning or an internal meaning to them. And they do. All right, now let's get back to it.
Capitalization. At Section 17.9, this same official U.S. government manual states, in the titles of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This wholly agrees with Texas Law Review's Manual on Usage and Style as referenced above. Examples shown in Section 17.12 are also consistent with the aforementioned Section 17.9 specification, that is, all proper names are to be spelled with capital first letters, the balance of each spelled with lower case letters. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, NASA, has published one of the most concise U.S. government resources on capitalization. NASA publication SP 7084, Grammar, Punctuation, and Capitalization. A handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. At Chapter 4, Capitalization, they state in 4.1 Introduction. First, we should define terms used when discussing capitalization. All caps means that every letter in an expression is capital, like this. Caps and esse means that the principal words of an expression are capitalized, like this. Caps and small caps refer to a particular font of type containing small capital letters instead of lowercase letters. Elements in a document such as headings, titles, and captions may be capitalized in either sentence style or headline style. Sentence style calls for capitalization of the first letter and proper nouns. Of course.
Now, this is clearly on the American side, even though, I mean, I don't know NASA's legal position. I believe they're just a corporation. So yeah, sure, they can write this, and they're an agency, I guess, of the government. But this doesn't make it law. This just means this is how we're going to be utilizing this internally. It's how we're going to look at it. This isn't the law. Okay. And they're once again talking about, I mean, they're not a legal department. This is grammar that we use based off of the original system, but it's never been made a law that, you know, and so it's weird to me because NASA is space, but this is how they use capitalization internally for them. But the states are different. So even though this is all good information about names and all that stuff, this is for the outside world, America. Inside the corporation, inside the corporate states, they operate under the UCC in conspicuous format. UCC 1-2001. So everything that you're going to hear in here, now they're going to start talking about the legal fiction. Okay, and then assumptions of it. So it's going to be a longer video, guys, but this is a detailed breakdown, probably the most comprehensive that you're going to find anywhere. So once again, shout out to the people who put all this together and found all these bits and pieces and helped us to bring this now to you guys. So let's keep going. But understand that you're talking about inside the system or outside. Right now, this is outside in America. Now we're about to go in as we go down through these next chapters where this person tries to close in on why the capitalized letters. But from what I see in here, I don't see anywhere, and I'm going to be listening here to see if I missed anything before, where they talk about the UCC book. Matter of fact, yeah, I don't see it anywhere in here. And the conspicuous format. So if I catch it and I remember in time, when I stop at the end of the video, I will open up the UCC online and show you once again, even though I've already done this in other videos, but I just wanted you guys to see the steps that people have gone through to try to prove what we've been talking about since before us. And now we actually have it. We've done it. We've combined the Black Laws Dictionary, the UCC, and these other bits and pieces in the GPO to prove what we've been talking about.
Course. Headline style calls for capitalization of all principal words, also called caps and LC. Modern publishers tend toward a down style of capitalization, that is, toward use of fewer capitals, rather than an up style. Here we see that in headlines, titles, captions, and in sentences, there is no authorized usage of all caps. At 4.4.1, Capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are always formed with capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing systems combine what you see is what you get. WYSIWYG features. Correct. The best electronic publishing systems combine what you see is what you get. WYSIWYG features. But Langley is involved with the National Aerospace Plane (NASP) program. This cites, by example, that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so that definition is required. Could this apply to lawful proper Christian names? If that were true, then John Smith would have to follow a definition of some sort, which it does not. For example, only if John Smith were defined as John Orley Holistic Nutrition of the Smith Medical Institute to Holistics, John Smith, would this apply. The most significant section appears at 4.5, Administrative Names. Official designations of political divisions and of other organized bodies are capitalized. Names of political divisions: Canada, New York State. United States Northwest Territories. Virgin Islands, Ontario Province. Names of governmental units: U.S. Government Executive Department, U.S. Congress, U.S. Army. U.S. Navy. According to this official U.S. government publication, the states are never to be spelled in all caps such as New York State. The proper English grammar and legal style is New York State. This agrees, once again, with Texas law. Reviews Manual on Usage and Style.
Okay, so right there, they're telling you New York State should never be spelled in all capitalized letters. Why? Let's take a look at it. Because New York State is the real organic American New York, and it's the state. If it's the real thing, it's just New York State. If it's not the real thing and you're not getting the real thing, it's called the state of New York. If it's just New York, the proper way is not to have the word of in there. It is New York State. That is it, pure. If it's a state or a piece of or acting like or on behalf of it, it has the word of. That then makes it a non-organic thing, non-living, non-real, and they call it State of New York. If I'm an honorary member of the Hill family, oh, James Lovett, he's an honorary member of the Hill family. Then I'm not a real Hill, am I? Because I would be just called James C. Hill. You put the word of in there, and it's not the real thing. So New York State should be upper and lowercase lettering, the American and organic. This is proper English and grammar. So we call it grammatical deception because when we see all capital, this is an inside club. This should not be. But when it's the state of New York, you capitalize it because it's a legal person created within their jurisdiction. Their rules are applying. It's a dead thing. They can't do business with the living thing directly. They have to have interfaces. Corporations talk to corporation. Dead talks to dead. So what happens when you use your all caps? You are the living and you're putting on your dead brother's or sister's body, their placenta, their vessel. You are operating as your brother's keeper, as it says in the Bible. You are becoming one with that entity, alter ego. You don't know where you start and it ends. You're wearing a dead thing, so you're wearing a demon suit or a dead thing to go into their jurisdiction. That's why I've been telling you guys this. So many people are like, oh, you're not right. Yeah, New York State, this is the organic way you're supposed to do it, right here, properly. Not this way, not for New York State. Now, the state of New York, yes, you capitalize it, but not the organic American version. That's this right here. Bum, bum, bum. Shot goes out to Percy J. All right, let's keep going.
Style. The use of a legal fiction. The Real-Life Dictionary of the Law. The authors of the Real-Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction. N. A presumption of fact assumed by a court for convenience, consistency or to achieve justice. There is an old adage, fictions arise from the law, and not law from fictions. Oren's Dictionary of the Law. From Oren's Dictionary of the Law, published by the West Group 1999, within the definition of fiction is found. A legal fiction is an assumption that something that is, or may be, false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish.
So understand that when they ask you on their documents, what is your name? They're actually asking what is your legal name and your legal signature. They want you to identify as the legal fiction. The legal name is a legal fiction. It's your nom de gore, Latin for war name. It is your straw man, is your alter ego. It is your public transmitting utility, transmitting energy through it. They say, and on their paperwork, it just says name. They like to drop the word legal. Why? Because they don't want you to feel uncomfortable. They don't want you to start to understand the ruse. But when you're doing something in their jurisdiction or applying for their benefits or services or licenses, it's all commercial and legal under the corporation. So a Brazilian nut in Brazil is just called a nut. It's not called a Brazil nut there. Why? Because when you're in their jurisdiction, it's assumed that you understand that you're in Brazil. So when you're in their jurisdiction, it's just understood that it's legal. That's why they just ask you for your name and your signature, because it's your legal name and your legal signature. They don't have to put that in there to alarm you, make you upset, uncomfortable. That's how the game is played. Let's go.
Establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law 1996 states: legal fiction, something assumed in law to be fact irrespective of the truth or accuracy of that assumption. Example: the legal fiction that a day has no fractions, Fields v. of Fairbanks North Star Borough, 818 p.2d 658, 1991. This is the reason behind the use of all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entity in all caps, they are legally stating that it is also intended to be a legal fiction. As stated by Dr. Mary Newton Bruder in the beginning of this memorandum, the use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to a legal fiction is assumption as noted in each definition above. Conclusion: there are no official or unofficial English grammar style manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by fiat, within and out of an undisclosed jurisdiction by unknown people for unrevealed reasons, by juristic license of arbitrary presumption not based on fact. The authors of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit. Assumption of a legal fiction. An important issue concerning this entire matter is whether or not a proper name, perverted into an all-caps assemblage of letters, can be substituted for a lawful Christian name or any proper name, such as the state of Florida. Is the assertion of all capital letter names legal? If so, from where does this practice originate and what enforces it? A legal fiction may be employed when the name of a person is not known, and therefore using the fictitious name John Doe as a tentative or interim artifice to surmount the absence of true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. It is an acceptance with no proof. Simply, to assume is to pretend. Oren's Dictionary of the Law says that the word assume means 1. To take up or take responsibility for, to receive, to undertake. See assumption. 2. To pretend. 3. To accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meanings of the second and third definitions with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive, or assumption, does not have the same meaning. Oren's defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the word assume are combined? In a literal and definitive sense, the meaning of assume would be the pretended acceptance, without proof, that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of the legal fiction John P. Jones in place of the proper name John Paul Jones implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong, it is considered valid. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps, resembling a proper name but grammatically not a proper name, is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, i.e. John Paul Jones, answers for or assumes the fabricated name, i.e. John P. Jones? The two become one and the same. This is the crux for the use of the all-caps names by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas or John Doe in their courts or on driver's licenses?
Okay, whoa, hold on. Let's talk about it here. So when they said that the government is doing this, yes and no. The government is under the Constitution, so they cannot directly do that, and they are, in fact, this is where we would differ slightly to what they're saying here. And to be on the side of the government for a split second, the government does not use it. They say that straight out in their capitalization rules under GPO style manual. However, if the states are using it, and then you happen to use it, and the government, well, they are over and superior to the states, because the states yielded a percentage of their sovereignty to be in the Union and underneath and in the American family, but not American per se. Then why would the government say anything? You're supposed to be competent, aren't you? So the government's like, look, man, um, if you use their stuff and you fall underneath them, then you fall underneath us. You're supposed to be competent to know what you're doing. Why should I interfere with that? Matter of fact, I can't by law. I can't interfere in your private businesses. So either you know what's going on, you're an intelligent, or you're a stoop. You're a simp. Your fault. Thanks for playing. For real. You never did the research. Now, how on God's green and beautiful blue marble could an average person sit down and put all that together, read all these books? You'd have to be a pretty smart individual, wouldn't you say? Age of the majority, intelligent, almond, mocha colored, and beautiful. And also worked with a whole bunch of other people who have worked tirelessly over the years to help bring in all these little pieces together so that we can finally see the full picture. Well, the government's like this, like, look, man, either you know what you're doing or you don't. And we didn't, and most don't, because in the state's jurisdiction, they don't give us access to their information, and they're not going to just turn over their books and admit to anything. That's the deception. Also, by law, they have to have it on their contracts, which are everything that they do are contracts, and they don't have it in a small writing. That is the grammatical deception and contractual deception that they've imposed. Let's get back to it. Holla at your boy.
Licenses? What stops them from doing this? Obviously, there is a reason for using the all-caps names since they are very capable of writing proper names just as their own official style manual states. The reason behind legal fictions is found within the definitions as cited above. The legalities of all capital letters names. We could go on for hundreds of pages citing the legal basis behind the creation and use of all capital letters names. In a nutshell, fabricated legal persons such as State of Texas can be used to fabricate additional legal persons. Fictions arise from the law, not the law from fictions. Bastard legal persons originate from any judicial/governmental actor that wishes to create them, regardless of whether he/she/it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation-states, all of which are artificial, corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation-states of that treaty. Representatives of the people in each nation-state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to the lawful process or created outside of lawful process? Executive orders and directives. For years many have researched the lawful basis for creating all-caps juristic persons and have concluded that there is no such foundation according to valid laws in due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all: executive orders and directives. They are color of law without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code, rules and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln establishes executive orders. 85 years after the independence of the United States, 7 southern nation-states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost and Congress was adjourned sine die, or without day. This meant that there was no lawful quorum to set a specific day and time to reconvene which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority, or lawful due process, of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more meritorious than so what are you going to do about it? Having a monopoly on the currency, law, and what passes for government, and most of the world's firepower, the motto of the powers that be is, we've got what it takes to take what you've got. Legal fiction laws, such as the Reconstruction Acts and the implementation of the Lieber Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on colorable fictitious entities created arbitrarily, out of nothing, without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules of rulership by force/conquest, originating from and existing in military, martial law jurisdiction. Military, martial law jurisdiction equals jurisdiction of war Equals win/lose interactions consisting of eating or being eaten, living or dying. Equals food chain. Equals law of necessity. Equals suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy or avoid being eaten, killed, or destroyed. Equals no law. Equals lawlessness. Equals complete absence of all lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity. Equals no lawful object, valuable consideration, free consent of all involved parties. Absence of fraud, duress, malice, and undue influence. Equals no bona fide, enforceable contract. Equals no valid, enforceable nexus. Equals absolute right to engage in any action of any kind in self-defense. Equals complete and total right to disregard any alleged jurisdiction and demands from self-admitted outlaws committing naked criminal aggression without any credibility and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military, martial law jurisdiction, with the only law being the law of necessity, i.e. the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win/lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins. Now, therefore, I, Harry S. Truman, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5(b) of the Trading with the Enemy Act of October 6, 1917, 40 Stat. 415, as amended, Section 5(b) of Appendix to Title 50, and Section 4 of the Act of March 9, 1933, 48 Stat. 2. Sic transit rights, substance, truth, justice, peace, and freedom in America, the land of the free and the home of the brave. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law. In this country, the law in effect in all but a few states until mid-19th century was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe v. Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e., executive orders and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida Statutes, 1999, Title 1 to Chapter 2, at Section 2.01 Common Law and certain statutes declared in force, it states, "The common and statute laws of England which are of a general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be of force in this state, provided the said statutes and common law be not inconsistent with the Constitution and laws of the United States and the acts of the legislature of this state." History. S. Dell, November 6, 1829, R.S. 59, G.S. 59, R.G.S. 71, C.G.L. 87. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes based on executive order and not the due process specified within the organic Constitution. Existing and functioning under the law of necessity ab initio, they are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e., organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any results other than disruption, conflict, damage, and devastation. The established maxim of law applies. Extra territorium just dicenti non peritor impune. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. 10 Company, store, room, applying it all to current laws. An established maxim of law states the importance of the name. Ad rect docendum opertet, primum inquirir nomina, quia rerum cognitio a nominibusrum dependit. In order rightly.
These are maxims of law, meaning like the in-between, the where the law is based on. And if you notice, this is the Latin, Roman, okay? And that's why a lot of things are based on those laws, which were the maritime laws. And those maritime type laws came from the merrymen who did merchandising, merchants, merry men, were the mermen. The mermen were the Atlanteans. So a lot of this stuff comes from there, and the people who taught them. But of course, it has been corrupted in its form now. But let's keep going.
Rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Company. Lit. 68. Title 3, Pleadings and Motions, Rule 9, Capacity, Federal Rules of Civil Procedure, states, in pertinent part. When an issue is raised as to the legal existence of a named party, or the party's capacity to be sued, or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement, correction, for all parties of an action of purported law. However, the current courts cannot correct this since they are all based on presumed/assumed fictional law and must use artificial, juristic names. Instead, they expect the lawful Christian man or woman to accept the all-caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed and a worldwide plunder/enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumption that you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all-caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statutes, Chapter 22, Section 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. American jurisprudence. In general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what, and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2D, at Judgments. Section 100 Parties. A judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the persons for and against whom the judgment is rendered. Technical deficiencies in the naming of the persons for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnote numbers and cites are omitted. The present situation in America. A legal person equals a legal fiction. One of the terms used predominantly by the present civil governments and courts in America is legal person. Just what is a legal person? Some definitions are: A. Legal person, a body of persons or an entity, as a corporation, considered as having many of the rights and responsibilities of a natural person and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person. I. A human being, a natural person. 2. A corporation, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporations in most definitions in this dictionary. 3. Any other being entitled to sue as a legal entity, a government, an association, a group of trustees, etc. 4. The plural of person is persons, not people, see that word. Oren's Dictionary of the Law, West Group, 1999. Person. An entity with legal rights in existence including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court either by themselves or by lawyer and, generally, other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity, such as a court finding of mental incapacity. Many laws give certain powers to persons which, in almost all instances, includes business organizations that have been formally registered such as partnerships, corporations, or associations. Duheim's Law Dictionary. Person, noun. Person. Latin persona, said to be compounded of per, through or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. Webster's 1828 Dictionary. A corporation incorporated under de jure law, i.e. by bona fide express contract between real beings capable of contracting, is a legal fact. Using the juristic artifice of presumption, or assumption, a device known as a legal fiction, implied contract, constructive trusts, another entirely separate entity can be created using the name of the bona fide corporate legal fact, the name of the corporation, by altering the name of the corporation into some other corrupted format, such as all capital letters or abbreviated words in the name. The corporation exists in law, but has arbitrarily been assigned another name. No such corporation, legal fact, nor any valid law, nor even a valid legal fiction, can be created under the law of necessity, i.e. under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption over unwary, uninformed, and usually blindly trusting people, can be legitimately exercised under no law. Anything whatsoever done under alleged authority of naked criminal aggression, i.e. law of necessity, can be rendered legitimate. Maxims of law describing necessity include: necessity has no law. Plowed. 18 and 15 Vin. ABR 534, 22 ID. 540. In time of war, laws are silent. Cicero. Non-existent law, the legal condition that universally prevails in the official systems of the world today, means that no lawful basis exists upon which anything can be created, or be made to transpire, upon which basis allegiance and obedience can be legitimately demanded. Acting under the law of necessity, i.e., lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor, and con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law and it is impossible for an attorney or judge to recognize or access it, you are not, and cannot be made subject to by them, in their jurisdiction. The crucial issue is then how to notice them of your position and standing. A person created under de jure law, with the person's identifying name appearing as prescribed by law and according to the rules of English grammar, is a legal fact. A corrupted alter ego version of that name, manufactured under the legal fiction of right of presumption, will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful? It is crucial to define the difference between legal and lawful. The generic Constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meanings? The following is quoted from a Dictionary of Law, 1893. Lawful. In accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing conformable to or enjoined by law. Legal, a thing in the form or after the manner of law or binding by law. A writ or warrant issuing from any court, under color of law, is a legal process however defective. See legal. Bold emphasis added. Legal. Latin legalis. Pertaining to the understanding, the exposition, the administration, the science and the practice of law, as the legal profession, legal advice, legal blanks, newspaper. Implied or imputed in law. Opposed to actual legal looks more to the letter, form/appearance, and lawful to the spirit, substance/content of the law. Legal is more appropriate for conformity to positive rules of law, lawful for accord with ethical principle. Legal imports rather that the forms, appearances, of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed, lawful that the right is actful in substance, that moral quality is secured. Legal is the antithesis of equitable, and the equivalent of constructive. 2 Abbott's Law Dic. 24, bold emphasis added. Legal matters administrate, conform to, and follow rules. They are equitable in nature and are implied, presumed, rather than actual, express. A legal process can be defective in law. This accords with the previous discussions of legal fictions and color of law. To be legal, a matter does not have to follow the law. Instead, it conforms to and follows the rules or form of law. This is why the federal and state rules of civil and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic persons named, e.g., State of Georgia or the U.S. federal government that rule the courts. Lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the organic Constitution has no bearing or authority in the present-day legal courts. It is impossible for anyone in authority today to access, or even take cognizance of, true law since authority is the law of necessity, 12 U.S.C. 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary, 5th edition, defines as color of law. The appearance or semblance, without the substance, of legal right.
Did you hear that? I've been telling you guys this. There's a difference between legal and lawful. Bam. Gem drop. Kick over the trunk. Let the cash, ass, and grass, and jewels and diamonds and gold rings and jewel and coins and all the goodies, let it all hit the ground. There it is. Told you. Let's get back to it. We're almost there, winding it up.
Misuse of power, possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Black's Law Dictionary, 5th edition, page 241. Executive orders rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevail instead of actual law. This takes place on a federal as well as state.
So this is not exactly true. It's not exactly true. The reason why is the Constitution and our common law haven't gone anywhere. We just haven't been using it. They replaced a lot of this stuff with their maritime admiralty jurisdiction, infringing on our rights, but not as U.S. citizens. These things apply to those U.S. citizens, those legal fictions. We just haven't been using common law. We haven't been invoking the Constitution. So it's been slowly being phased out. Not so much phased out, it's still there. It always will be. Because, see, they can't really get rid of the Constitution because the Constitution gives them the power to do what they're doing. So they don't like it, but it's like if you get rid of that, that's your foundation to your house. So if you can't get rid of it, either you need to bury it or force the people who can change it and get rid of it, the American national, or excuse me, the nationals and state citizens of America. Those are your choices. Convince the people that we don't need that anymore, or bury it so deep that nobody makes any claim to it anymore. And it has been effectively and functionally eliminated.
State level. Government administrates what it has created through its own purported laws, which are not lawful, but merely legal. They are arbitrary constructs existing only because of the actions of people acting on fictitious, self-created authority, i.e., no authority. They are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census.
Now you understand when I said way back when COVID, which for the COVID, which helped to make my channel popular. And I said it's not a law. It was never passed as a law. The president never said it was a law. He said it was a mandate. That's not a law. That is an order from a commander-in-chief to its subordinates. We, the American people, are not subordinate to the president, not as nationals and state citizens. As U.S. citizens, yes, but not in our proper standing. Starting to make sense now? You guys starting to see the game? Hope so.
Census 2000 reveals that the legal authority for this census comes from Office of Management and Budget, 0 megabytes, approval number 06070856. The 0 megabytes is a part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economics and Statistics Administration of the U.S. Department of Commerce, USDOC. The USDOC is a department of the executive branch. Obviously, Census 2000 is authorized, carried out, controlled, enforced and implemented by the President, the executive branch of the federal government, functioning as it has been since 1861, in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the President controls the entire nation through various departments and agencies affecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more, through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for these executive orders on Article 2, Section 2 of the U.S. Constitution. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the United States. He shall have power, by and with the advice and consent of the Senate, to make treaties, providing...
Hold up. Nowhere in there did you hear them say the nationals, the citizen, the private citizen. What they said is there is the militia, which means any militarized people or entities, but then it says of the several states. The several states means the organic United States of America, the Republic, New Yorkers, Floridians, Florida, not state of Florida, Florida. So there's a difference there in the words. You think you understand these words, and maybe you do understand them to the best of your ability, but you don't understand the word correctly. Some of these things have double meanings, and they're using either one or the other. They cannot use both meanings in the same. I mean, they can refer to the different states, but here they're talking about the several states. That's the organic. All right, let's keep going.
Provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of departments. In reality, the Congress is completely bypassed. Since the Senate was convened in April 1861 by Presidential Executive Order No. 2, not by lawful constitutional due process, there is no United States Congress. The current Senate and House are, like everything, colorable, color of Senate, under the direct authority of the executive office of the President. The President legally needs neither the consent nor a vote from the Senate simply because the Senate's legal authority to meet exists only by executive order. Ambassadors, public ministers, consuls, federal judges, and all officers of the United States are appointed by, and under authority of, the executive office of the President. The Federal Registry is an executive function. The first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, and the Amendatory Act of March 9, 1933, the Banking Relief Act. In the Amendatory Act, every citizen of the United States was made an enemy of the government, i.e. the Federal Reserve/IMF, et al., creditors in bankruptcy who have conquered the country by their great paper money banking swindle. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register, OFR. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is found within the United States Code, Title 44, at Chapter 15. Section 1506. Administrative Committee of the Federal Register, Establishment and Composition, Powers and Duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or Acting Archivist, who shall be chairman, an officer of the Department of Justice designated by the Attorney General, and the public printer or acting public printer. The Director of the Federal Register shall act as Secretary of the Committee. The Committee shall prescribe, with the approval of the President, regulations for carrying out this chapter. Notice that the entire Administrative Committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The President does. This act also gives the President the authority to decree all the regulations to carry out the act. By this monopoly, the executive establishes, controls, regulates, and enforces the federal government without need for any approval from the Senate or anyone else, other than his undisclosed superiors. He operates without any accountability to the people at all. How can this be considered lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm United States vessels traversing hostile German waters before the United States entered World War I, so Wilson simply invoked the policy through a presidential executive order. President Franklin D. Roosevelt issued Executive Order No. 9066 in December 1941, forcing 100,000 Americans of Japanese descent to be rounded up and placed in concentration camps while all their property was confiscated. Is it any wonder that the Congress, which the President legally controls, did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming? On that note, why is it that attorney presidents have used executive orders the most? Who, but an attorney, would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful since the entirety of their authority, which is ethically and existentially specious, derives from the war powers. How debt is assumed by legal fictions. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrarily created juristic persons, e.g., State of California or John P. Jones. Since an assumption, by definition, implies debt, what debt does a legal fiction assume? Now that we have explored the legal, executive basis of the current federal and state governments, it's time to put all this together. The government use of all caps in place of proper names is absolutely no mistake. It signifies an internal, legal, rule and authority. Its foundation is pure artifice, and the results have compounded into more deceit in the form of created, promulgated, instituted, administered, and enforced rules, codes, statutes, and policy, i.e. the laws that appear to be but are not, never were, and never can be. Consentit commodum, sentire debet eti onus. He who enjoys the benefit ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments, themselves specially created, juristic, corporate persons signified by all caps, have issued birth certificates to persons with legal fiction all caps names. This is not a lawful record of your physical birth, but rather the birth of the juristic, all caps name. It may appear to be your true name, but since no proper name is ever written in all caps either lawfully or grammatically, it does not identify who you are. The birth certificate is the government's self-created document of title for its new property, i.e. the deed to the juristic name artificial person whose all caps name mirrors your true name. The birth certificate brings the new all caps name into colorable admiralty/maritime law, the same way a ship and ship of state is birthed. One important area to address, before going any further, is the governmental use of older data storage from the late 1950s until the early 1980s.
Now you see why your main man, the wolf, even though all these gurus are out here, don't listen to the wolf. All this other jazz. When I was telling you guys about authenticating the birth certificate, they were like, no, I don't do that. There's no merit to it. Nobody else was talking about it. Nobody. I put it out there. I took all the attacks, all the ridicule. Yeah, I remember my first beer, and then all of a sudden everybody started doing research in it. And then everybody started saying, oh, you need to do that. Now understand, you don't have to do anything. If you overstand the information and you want to make the changes, you do. Otherwise, if you want to be private, you just be private. Don't use their stuff or use it the appropriate way. We authenticated the birth certificate because it pulls it out of one jurisdiction and puts it into the private. We've already proven this. We've done it a cajillion times. But yeah, I'll admit, when I first started talking about it, all these people were like, yeah, I wasn't 100% sure. I'm not going to lie to you, but I believed it. It's what I read and it made sense. And then I talked to legal departments and they said, yes, this is how you do it. Privately, of course. So here we are. Thank you for those people who had faith in me and believed in me and did these things and made the proof to be shown in the pudding. To the other people out there who didn't believe in it, still don't like me for your reasons, I don't give a. When you talk about me, you just help me to make me famous. That's all I can say. Let's get back to it, shall we? We're almost there. Bear with me, guys.
1980s. As a leftover from various teletype-oriented systems, many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps, when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, and birth certificates and other important documents, such as driver's licenses, were produced with typewriters, it's very doubtful that this poses much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older databank all-caps storage systems would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. Automated computer systems, with daisy wheel and pin printers used prevalently in the early 1980s, emulated the IBM Electric Typewriter Courier or Helvetica fonts in both upper and lower case letters. Shortly thereafter, the introduction of laser and inkjet printers with multiple fonts became the standard. For the past 15 years, there is no excuse that the government computers will not accommodate the use of lowercase letters unless the older data is still stored in its original form, i.e. all caps, and has not been translated due to the costs of re-entry. But this does not excuse the entry of new data, only legacy data. In fact, on many government forms today, proper names are in all caps while other areas of the same computer-produced document are in both upper and lower case. One can only conclude that now, more than ever, the use of all caps in substitution the writing a proper name is no mistake. When a child is born, the hospital sends the original, not a copy, of the record of live birth to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Services, HRS. Each state is required to supply the United States with birth, death, and health statistics.
Keeping in mind that the word child also means their property. The result of the merger of two corporations. Your kid should be referred to as your biological offspring. Bio meaning living, human, material, matter, offspring, natural. Let's keep it moving.
Statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted, all caps version of the baby's true name, i.e., James Wilbur Smith.
Now, Wolf, how can you prove that? Well, if you haven't watched my other videos, this is your first one, man, you're in for a hell of a ride. If not, you should be hitting that bell, like, and subscribe about now, and hold on to your pants, Dorothy, because Oz is about to go bye-bye. So if you look at your birth document and it doesn't have any living information, doctor's name, mom, dad name, and signatures, birth time, eye color, hair color, skin color, nationality, orientation, etc., etc. If it does not have that information, they birthed a legal person. A dead thing, an entity, doesn't have those things. It has the form, the look of a man or a woman, but is not, in fact, a biological individual. If it has those things on there, it's either the original certificate of live birth, keyword in there, live, or it's a certified copy, which is just as good as the original, legally speaking. Let's keep going.
Certificate, noun. Middle English certificat, from Middle French, from medieval Latin certificatum. From late Latin, neuter of certificatus, past participle of certificare, to certify, 15th century. 3. A document evidencing ownership or debt, Merriam-Webster Dictionary, 9.
So the word certificate means either ownership or debt.
1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the executive office.
So remember, there's a difference between getting the one that they don't want you to have, which is the heirloom or the baby footprint one, also called the souvenir, so they can downplay it. Oh, why do you want the heirloom? I don't know. Heirloom means in the family and passed down. Why do you want the souvenir? Oh, yeah, that sounds like you're just on a vacation on a trip. Well, that's going to cost $100 or $150 for that document. Oh, well then, yeah, I don't want that. What else do you have? Oh, well, I mean, can you put it on my bill? Nope, can't do it. It has to be cash. Has to be paid. It's separate. Yeah, let's set up a whole bunch of bullshit ass little obstacles to lean and wean the person towards where they want. Well, what else do you have? Well, we've got a certificate of live birth. Here you go. Here's two of them. Okay. So that's okay. It's okay. It's not great. Then later on, some twat waffle comes walking in there and says, oh, the state of Texas, the state of Florida, the state of California says you must register your child. Yeah, that's true. If you're claiming that the birth was a U.S. citizen instead of a Californian or New Yorker or Floridian or Texan or Wisconsinite. I'm not. This is a private birth, private citizen. Show me the law that says I have to get it. Is it free? Well, yeah. Just give us one of those certificate of live birth. Okay, so remember they said that means either ownership or debt. So you want me to give you the ownership document over my offspring so you can return it to a now it's going to be reversing the words and removing the word live, a birth certificate, which then either means that I am now giving you ownership over my child, or I'm placing my child in your debt. Huh. Let's keep going. If y'all ain't learned something by now, if y'all ain't clicked that like button, if y'all ain't supporting me, then you're doing exactly what they want you to do. Not to support, not to like, not to share, not to send in donations, and stay in your little cage. I mean, $1, $5, $10, anything, all that's accepted. You don't have to be a multi-millionaire to support here. You sending $5 to my Cash App or on my PayPal. One, it means a lot to me because it means that you actually do care and you are getting some value from this. And if 20 people do it, well, then that's $100. Hey, that's cool for me. I can buy lunch, you know, whatever. 2 days, 3 days, some coffee. Appreciate it. Let's keep going.
Office specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states.
Now, mind you, I made the video where I showed you that they make money. That was their document, not me. I did not make it. That was their document. Available on the internet. They're not hiding it. I showed you that they make money off of your information and the documents they give you and on your passing. They get you coming, standing, and going. Let's keep going.
States. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all-caps name was merely noted in a book for reference purposes.
Nope, because that would be recording. There's a difference between recording and registering, driving and traveling, private and public. They're English words, but if you're activity with them, if you're in activity with them, you have to be careful because those same words have different meanings.
Purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all-caps legal person named thereon has become a surety or guarantor.
Okay. But you didn't register it with them. The hospital coerced you into getting it done, giving it to them. They sent it to the state sent it to the commerce, made their money on it, sold it to other people. They're assuming you are the surety or grant. Well, okay, hold on. Out of these two, you're not both. You can technically be both at any one point, but to them, you're either the surety or the grantor. The grantor means the same thing as the trustor, meaning you created it. The surety means you're responsible for it. They always assume you're the surety. Because if you're the grantor, you are their boss and you have control over it, and they don't. And because you don't know how to tell them right or claim the age of majority, they're going with that you're the surety. Physically, financially, mentally, all of that. The straw man, the legal person, was always meant to be a shield, a ship, a mask, a suit, all in one for you to protect you from them, to do work in their area, in their demon mines, pull out some gems and gold, some rubies and sapphires and ingots, and then bring it back to the private, to America. You're supposed to work in hell and kick your feet up in heaven with your winnings and spoils, but you didn't. You kept it in hell. Ba, ba, ba. And then you said you're responsible for it no matter what you do, no matter what happens. right or wrong, I'll take the blame.
Name in all caps.
All right. Let's see here. All right. We'll just start back right here. Right. We were down farther. Yeah, here we go. Okay.
Name in all caps. He birth certificate. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the Executive Office, specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all-caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all-caps legal person named thereon has become a surety or guarantor, a condition and obligation that is automatically and unwittingly assumed unless you rebut the presumption by effectively noticing them. It ain't me.
Boom.
Registered. Security, bond. Merriam-Webster Dictionary of Law, 1996. Bond, surety, 1. Undertaking. 2. One who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor, and the two terms are generally interchangeable.
So here, they're saying basically this is the same thing. If you created it, you're responsible for it. But here's the problem. Even the UCC operates in trust law. So generally interchangeable does not mean 100% interchangeable. Under trust law, surety is the person who's responsible for it. Grantor is this. So the grantor in the trust position is the creator of it. The thing itself is its own entity. The trustee who operates it is the surety. They're the responsible party for it. In this case, it would be them. The grantor creates it. The surety who gets paid is the trustee who's responsible for it. And then there's the beneficiary. Guess who's the beneficiary? That's you.
Interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor. A person who pledges collateral for the contract of another, but separately, as part of an independently contract with the obligee of the original contract.
So right there, they just broke it down. You're not responsible for it. You're independent. This is a contract. I'm independent. I'm providing this, but I'm walking away.
Name in all caps. It is not difficult to see that a state-created birth certificate, with an all caps, name is a document evidencing debt the moment it is issued. Once a state has registered a birth document with the U.S. Department of Commerce, the department notifies the Treasury Department, which takes out a loan from the Federal Reserve.
Hey, whoa! All that stuff Wolf was talking about. Let's go.
Reserve. The Treasury uses the loan to purchase a bond. The Fed holds a purchase money security interest in the bond from the Department of Commerce, which invests the sale proceeds in the stock or bond market.
All those people out there who didn't believe my video, how much are you worth? They're trading your stuff on the market. Your Q-tip, here it is. They're breaking it down right here for you. Boom, boom, bada boom, boom, bada bing, bing, bada boom. My only problem was finding out either how to cash that in, if we can cash it in, because we don't know if we have the legal right to it. Because we don't, if we are the surety, the responsible party for it, the trustee, we can't put our hands on it. Only the grantor or the beneficiary. They don't tell us how to do it, where to do it, etc. So that's the problem. And they don't really want us talking about it. So this is all education and entertainment purposes, not to be construed as fact. Do your own research. Let's keep going.
Market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, and bills using the bonds as surety for the new securities.
Your birth certificate, CUSIP number, other documents they give you, if it has a CUSIP number on it, this is what they're doing.
Securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate.
Because they know that you're going to put all of your stuff underneath this straw man birth certificate name, this legal person. They know if in the course of your life, you're going to put a lot of money into that name. Houses, property, assets, bank account. Hell, even the job. I can't tell you exactly what agency, but let's just say somebody from one of the agencies who worked there didn't believe what I was saying, looked up their own information, and they were blown away. And they said, why is it worth so much? I said, because you, unlike me, you worked for them in a specific area. These areas are valuable. So they traded yours in a more valuable pool. I'm just Joe Blow from Kokomo. So I got the low end or the medium end of it, but still yet it's worth more than certain other ones because of what I've done in my life and other things. So that's why they're not all going to be the same. But he said, well, why is this other one that I checked about the same? It's the same figure. I said, because both of them were traded probably in the same or similar pools in the same year at the same rate. But yours will be different than your brother, sister, mother, wife, or cousin, or best friend, or whoever else's. Not all the same. Not all of the cattle. Do you hear what I'm saying? Not all of the cattle are going to have the same value. That bull over there with the big balls and the big back is worth more. All right, you get where I'm going with it. Let's keep going.
Certificate. This also means that the bankrupt, corporate U.S. can guarantee to the purchasers of their securities the lifetime labor and tax revenues of every citizen of the United States/American with a birth certificate as collateral for payment.
They're pimping us, pimping. They've been pimping since pimping was pimping. Or do you want me to do that over in my my pimp voice? See if I still got it. They've been pimping since pimping was pimping. They've been pimping you. They have people around the world buying us up like stock animals and our assets. You think you own your home? You think you own that car, that whatever? Not legally. You don't even own your name. You don't even know who you are. You've never even claimed the age of majority. You got all your stuff out there underneath your legal name and not in a private trust. And well, if you need a trust, I sell them on Black Site 32. Definitely one of the cheapest on the market, professionally written. Let's keep going.
Payment. This device is initiated simply by converting the lawful, true name of the child into a legal, juristic name of a person.
I would change child into biological offspring, but you guys get it.
Name in all caps.
Oh, son of a.
A birth certificate as collateral for payment. This device is initiated simply by converting the lawful, true name of the child into a legal, juristic name of a person.
They create a legal version of you. Just like right now, you could go out and create a company called uh, Badwolf Incorporated. Let's just call it Badwolf. Still a corporation, but let's call it Badwolf. And then you name yourself Badwolf. Everything you then put in the name Badwolf, they're like, well, it's all capitalized. It's in our jurisdiction. It's ours. Let's pimp it, pimpin'. You got, fool. It's a
Person.
full-time jack move.
Debuque re podicinia pars prinipium est, the principal part of everything is in the beginning. Well begun is half done. Legally, you are considered to be a slave or indentured servant to the various federal, state and local governments via your state-issued and state-created birth certificate in the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license or a social security account number. The state even owns your personal and private life through your state-issued marriage license/certificate issued in the all-caps names.
So this is not accurate. They do not own your private life, but they, through the marriage license, have then turned what you thought was a private personal marriage into a public thing that they are then involved in a three-way scenario, which then violates your biblical or Bible because you are operating in a three-person marriage. But it's not a real marriage. It's just they use the word marriage, marrying age. So to marry means to bring things together. This is a corporate merger. Remember, they do everything corporate and legal. So they can't even give you a real marriage. They can't. But they can merge your trust, your corporation, your business trust, your straw man with another one. They can put two dead bodies together and be the undertaker for them. They deal in dead things, not living. So they merged your trust, your business trust that the state created, your legal person, your straw man, your nom de gore, your two public transmitting utilities. So they're not involved in your private life. What you thought was your private life, you made public. And now they're involved in it, hoping that it doesn't work out. So that the moment that it doesn't work out, and I hate to say this, so don't take it personal, but this is how the system works. If I hurt your feelings, sorry, not sorry. If you don't know these statistics or what I'm about to say, then turn away now. Don't message me crying about what I'm telling you, or if I offended you. I don't care. I mean, I care about you as a person, but I don't care about your feelings in this matter. When you, and here, I'm going to show my face. Let's get back. Put them. Once again, sorry, not sorry for what I'm going to say. All this is facts. When the marriage doesn't work out, if you look at the marriage statistics, 70% of marriages are filed by females. The female, they have psychologically analyzed and they have been attacking on multiple levels by what's known as civil or um, civil engineering or social engineering. You guys can be free and independent. And hell, I was raised by a woman. Okay, a great woman. God rest her soul. Two women, actually, mom and my sister. I speak very almost fluent woman. The modern day female, not all, but to those at which this applies, they don't want you to have a healthy marriage. They don't want you to have a healthy mind. They have replaced everything that a good man, not a full-size boy like most of you have dated, with the system. So yes, it's easy for a female to say, I don't need a man, because the system has replaced everything a man, a good man, would normally do for you. You don't need a good man because you don't need him to protect you, because you've got the police, which are almost, well, never there when something bad happens, but they clean up, but we'll leave that alone. Sometimes they do. No offense. Some are great, some aren't. If you can't take care of the kid, you don't need the man, because you can put him on child support or get money from the state. All these things that they do are because these are service things that they can provide to you, and remove the man and then make the man look inept. You don't need a man. And I'm not saying you actually have to have one to physically live, but at night, do you prefer to look at pictures of the judge and the police officer and say, oh, those are my men right there, or have an actual man or a great woman by your side? The real thing is almost always going to be better if they're a good woman or good man in your life. Other parts to it. The court has figured out if they can social engineer females, and by females, I'm not talking about women who overstand this information and who are great. I'm talking about the females out there who are, just out here trying to be like baby mamas and stuff. And my booty hole brown and all the rest of the other jazz that they fill your heads up with. I'm talking about the ignorant ones out there. They do these things because they know, they've seen it. So they're engineering you to be ignorant and not to rely on anybody, which you should not have to rely on anybody. Hell, not even the system. The system is in place to help those people who actually need it, not as a lifelong crutch. But they want you to be that lifelong crutch because that makes them money. They don't want you out of the system and cured. They want you to stay in it so it makes them more money. But they've also psychologically analyzed that the female in a relationship will be the one who argues or complains the most or the loudest. Statistically, males, make more money. Logically, this then means take the money from the one who has it and give it to the one who complains. This is a profitable business. This is why they do these things. I don't care how any of you guys feel about this particular segment. This is a fact. We've seen it. The guys know exactly what I'm talking about. And even the females go, well, I mean, I do have child support. I do have alimony. Marrying a male who is successful can be a business come up for the female and for the state. Sorry, guys, but marriage on a state level has a, what is it? 72% success of failure, when in fact you could create your own private agreement, or you could put your men and women can do this. It doesn't just, I'm not saying 100%, I'm saying a majority of the system operates this way. There's definitely ways and times and events where this is switched and he goes and marries her and he takes her money. It's not as much, but it does happen. So what I'm saying is for everybody, but you have to hear the facts. Don't care if it hurts your feelings. Tear gone, sad no more. The thing about this is that you all can put your stuff in private trusts before even getting married or having a common law or civil union, a private marriage, private union, whatever you want to call it. Matter of fact, that's one of the reasons why I love my lady is because we've talked about things like this. And if we get to that point, she's already on board. It's like, hell yeah, I would love to have a private uh thing. I don't want the state or anybody in our business. But when you write up your own, and I've already made a video on this, you want to include all of the hard talks. What if we have kids? What if you cheat? What if I cheat? What if we both decide? All these things you need to have in your agreement pack, signed by witnesses there when you join. Get it notarized. It then becomes a legal, binding, and lawful contract. And if you guys derail from something in there, either you both agree, because you both need to have a copy, you both agree to add new copies and a new set of witnesses and notarization on both documents, and then you're good. That's how I would do it. Let's get back and wrap this up.
Name in all caps.
Ah, other Skype. All right, we didn't get to bankruptcy, so where was it? They read some Latin there. Driver's license, state marriage license, all caps. All right, here we go.
The all caps names. You have no rights in birth, marriage, or even death.
Now, when they say birth, they really mean the BERTH, birth of the legal man. Marriage is their construct, so you don't have it there. And then in death, you don't have any rights because you're dead, but somebody else has the rights over your estate if you have everything in your trust. If not, they then administer your estate publicly because your name is on the public side. It's administered. Administration, public law, public administration, public ordinance. You notice how none of those things ever say private because they have no jurisdiction over the private citizen as long as you have not committed a crime or endangered public safety.
Death. The state holds title to all legal persons the state creates via birth certificates until the rightful owner, i.e. you, reclaims/redeems it by becoming the holder in due course of the instrument.
Which is what a lot of you guys do not know how to do properly. We will be, even though I gave you guys the age of majority, we will be going possibly into this. Now, how to redeem things, don't email me or message me. Once again, I do not know how to properly redeem anything other than your rights, but not the financial aspect. I don't know. They keep that stuff locked up. It's only theoretical at this point in time. But we will cover some theory in another video.
Instrument. The main problem is that the mother and father, and then the 18-year-old man or woman, voluntarily agreed to this contrived system of plunder and slavery by remaining silent, a legal default, latches, and failing to claim one's own rights. The maxim of law becomes crucially operative: he who fails to assert his rights has none.
So that's a maxim of the law. They're saying if you don't assert and claim your rights, then you don't have any. You don't speak up and invoke them, you don't have any. The parents fraudulently put their offspring, who then became a child, into the system. Then you got to be 18 and you did it to yourself. You contracted deeper with the bank account and the whatever. Now, understand that this does not mean that the straw man is evil. It's just used in a negative or malicious way at times by them. But there's nothing wrong with having it if you know what it is and how to use it. But that's where they get you because most of you guys don't.
None. The legal rules and codes enforce themselves. There is no court hearing to determine.
We froze her up. Or they were like, yeah, quit telling all the goodies. Let's try it again. Let's go. I think that's it. She's done. All right. So we'll just finish up here. There is no court hearing to determine if those rules are correct. Government rules are self-regulating and self-supporting. Once set into motion, such laws automatically come into effect provided the legal process has been followed. All right. So in here, they go to talk about bankruptcies based on the legal all caps, which is trash. Government is responsible for all of our debts when you claim it properly. All caps, legal person versus the lawful being. I'll try it one more time.
All caps legal person versus
There we go.
the lawful being. Just who or what is the all caps person, i.e., John Paul Jones, John P. Jones, or some other all capital letter corruption thereof? It is the entity the government created to take the place of the real being, i.e., John Paul Jones. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers as the legal person, the two are recognized as being one and the same. However, if the lawful being distinguishes himself/herself as a party other than the legal fiction, the two are separated. A result of the federal bankruptcy was the creation of the United States, which was made a part of the legal reorganization. The name of each state was also converted to its respective, all-caps legal person, e.g. State of Delaware. These new legal persons were then used to create more legal persons, such as corporations, with all capital letters names, as well. Once this was accomplished, the con began to pick up speed. All areas of government and all alleged courts of law are de facto, color of law and right institutions. The Circuit Court of Wayne County and the U.S. District Court can recognize and deal only with other legal persons. This is why a lawful name is never entered in their records. The all-caps legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned, common law venue court. Unfortunately, such jurisdiction was shelved in 1938 and is no longer available. The only courts today are statutory commercial tribunals collecting tribute, plunder, from the alleged creditors who think they have conquered the country on their way to ruling the world.
So that's not 100% accurate because there are equity courts. They just don't want you to know about them. However, it's also the fact that there's only like 3 left. And some people still argue that they're really not truly de jure, but they're called equity courts and they do the same function. So, as far as I'm concerned, they are the last line in the sand other than the Supreme Court. And I think there's one in Tennessee. You have to type in like Equity Court of Tennessee, and there's like 2 more. Or there ain't much left of America other than what's inside of each and every one of you guys. And as a patriot, non-belligerent, leader of Levitica, I'm letting you guys know that the future is in all of our hands. We have to know who and what we are. It's not about getting rid of the system and kicking them out of the country. That's not what it's about. I mean, off record, that would be great. But we would still need somebody to operate the systems. But they should be doing it as Americans, not the moment they step into work and become these municipal and officers and whatever else, becoming international, foreign to the United States of America operatives, pretending to be our fellow Americans while they're not, while they're in office. Then subject to doing their commercial activities here on our land. What you guys do with the information is up to you. Obviously, we accept no don't mind me, I'm watching one of my security cameras. It's always funny when you put stuff out in the trash and then people drive by and they just take it for whatever the reasons are. I don't know. It's just funny. I enjoy it because it's just like watching things be recycled and it's rehoming. Anyway, so it's just funny. People took a whole bunch of boards I had out there, put them on top of their roof of their car, and they're just driving off with it. No bungee, no rope. They're just like, ah, we'll just drive slow. It's fine. So whatever it is, it's all good. So that also being said, try to find a moment or a way to laugh and a way to breathe. You can do as much of this stuff or as little of it as possible. As it's all upon you. Be careful with everybody's methods and what you're getting. Vet the information. Do your own research. Don't let it overwhelm you. But at the same time, you should know what it is, because if you do not teach yourself this, and then your family or those who will listen, do not go out there trying to convert people. That's not what this is about. Learn it if you want to learn it. Let people come to you and ask questions. And if you can't answer them, send them my way or somebody equivalent that you trust. In wrapping up, all I can say is to the other nationals out there, or U.S. citizens or state citizens, or whatever you guys want to call yourselves, depending on who you are, look, if you're against other people who are doing a good job in sharing the information, and you, in fact, are a traitor to the United States of America and your fellow nationals and slash state citizens, you are doing their job for them, and they couldn't be more proud of you. If you consider yourself a man, then operate like an American man. If you consider yourself to be a woman, then operate yourself like a woman. I've come to find out that there are so many people out there that are male and not men, females, but not women. Boys, you get where I'm going with it. They want to keep you uninformed, and the choice is yours. Take care of yourselves out there. Whatever situation you're in right now, don't let it be what defines you. This is but one moment before you can climb to the top of a mountain to reap, benefit, or gain that which you desire and you dream of. It starts with your first step at the base of the mountain. If you want to move a mountain, you can't push it, but you can grab a handful of stones at the base of it, walk to where you want it to be, and cast it down. In casting down these stones into this ocean, ripples are made. And now these ripples are made, they cannot be brought back. You've heard this message as Americans from a patriot. The bell has been rung. That which has been wrong cannot be unheard. What you do with it is up to you.